Hello, everyone, and welcome to today's webinar, where we will be discussing updates to federal policies, regulations, guidance, and legislation impacting the energy, transportation, and water sectors. My name is Rebecca Hayes-Barho. I'm a partner in Nossaman's Austin office with the Environment and Land Use Group. Joining me today are partners Sven Brand Erickson, Sarah Johnson, and Brett Marcus, each of the Environment and Land Use Group, and Anne-Therese Schmid, who's a partner in our Infrastructure Practice Group. Before we get started, I want to go through a few housekeeping items. Following the sending you an email with a link to the recording and the slide deck. That email should come to you within 24 hours or so. At any time, you can submit questions in the side panel. You should see a Q&A icon in your Zoom window. If you input your number when you registered, you will receive an MCLE completion certificate via email within about a week. And then if you have time when the webinar ends to answer a few questions on a survey, we would greatly appreciate it. We're always looking for ways to improve the experiences and information. So here's a roadmap for today. We're going to start by talking about legislative, administrative, and regulatory activity that affects a broad variety of sectors and projects. And then we will move on to discuss activities that impact each sector specifically, beginning with renewable energy, and then water, followed by transportation. And at the end, we've left a little time to answer questions that we received when you registered, and also try to get to questions that you ask in the chat during the webinar today. So we're going to start out by talking about a couple of presidential actions affecting a broad variety of sectors that have occurred since our last webinar on executive orders. On April 9th, President Trump issued a presidential memorandum directing the repeal of unlawful regulations. This presidential memorandum directs agencies to repeal regulations or portions of regulations the agencies believe clearly exceed their statutory authority or that they believe is otherwise unlawful. The memorandum directs agencies to repeal these rules or these provisions of rules, portions of rules, without providing for public review and comment, using the Administrative Procedures Act good cause exception. As you may remember, that good cause exception was used under the Biden administration when that administration updated the definition of waters of the United States to comply with the Supreme Court decision in Sackett versus the EPA. Finally, the presidential memorandum directs the agencies to prioritize repealing regulations that are in conflict with a number of Supreme Court cases, including Loper Bright, which did away with Chevron deference, Sackett versus the EPA, which narrowed the scope of the definition of waters of the United States, and West Virginia versus EPA, in which the Supreme Court explained for the first time that an administrative agency has no power to make decisions on major questions of extraordinary economic and political significance. That case dealt with the EPA's use of kind of curtailing generation sources for greenhouse gas emissions. Then on, I believe it's actually May 23rd, not April 23rd, President Trump issued Executive Order 14303, Restoring Gold Standard Science. Essentially, that EO creates a policy where we go back to the first Trump administration scientific integrity policies. Agencies are directed to comply with the EO within 30 days. It establishes a weighted scientific evidence standard for agency decision-making. Importantly, it cites to a DC Circuit Court of Appeals opinion, Maine-Lobsterman, and says that agencies should limit the use of the precautionary principle. That case dealt with endangered species. Essentially, the DC Circuit Court said you really shouldn't be resolving every issue of uncertainty in favor of the species. The EO also requires agencies to review bind administration regulations, guidance, policies, and scientific determinations to ensure they're in line with the EO and its policies. And finally, the EO makes clear that agencies should be making publicly available the data, models, analyses, and other information they use in their decision-making process, with the exception of information used in connection with enforcement actions. So we're going to start with the National Environmental Policy Act. There's been quite a bit of movement since January 21st. As you recall, Executive Order 14154, Unleashing American Energy, among other things, directed the Council on Environmental Quality repeal its National Environmental Policy Act regulations and issue instead guidance that agencies should follow when they are implementing NEPA on an agency by agency basis. On February the 19th, CEQ issued guidance directing agencies to propose, to rescind or revise their own regulations, and also directed them about what they should consider when they are making updates to their NEPA implementing regulations. Then on February the 25th, CEQ rescinded its NEPA regulations. Just last month, agencies began issuing interim final rules, either repealing in full or in part, or revising their existing NEPA regulations in order to comply both with the executive order and CEQ guidance. There's also some ongoing legislative efforts, and I'll briefly touch on where lawsuits sit in just a moment. So here are a few, some links to the Federal Register notices for a few agencies that might be of relevance to the sectors that we're talking about today. As you'll see, the Department of the Interior rescinded most of its regulations, as did the Department of Energy. The Department of Transportation made substantial revisions to its policies, while the Corps rescinded their regulations and have replaced with guidance. So starting with the Department of the Interior, the department rescinded all of their NEPA regulations with the exception of completing NEPA in the context of emergency situations. They left in place their generalized categorical exclusion regulation, and they also left in place and made some revisions with respect to provisions addressing when applicants and their contractors prepare NEPA documents. Those updates were made in response to the Fiscal Responsibility Act. The rest of DOI's NEPA implementation procedures have been moved to guidance, and you can find that guidance on DOI's NEPA website. It's a short guidance document with a few appendices. The guidance includes a list, an exemplary list of things that would qualify for categorical exclusions. Of interest, under the guidance, it appears that incidental take permits under Section 10A1B of the Endangered Species Act may actually qualify mostly as categorical exclusions, that wouldn't be limited just to low effect habitat conservation plans, as has been the case in the past. And then that guidance clarifies what constitutes a major federal action in the eyes of the DOI. And I wrote that down here. It says NEPA does not apply to actions with no or minimal federal funding or with no or minimal federal involvement where a federal agency cannot control the outcome. And then in parenthetical, they say that control over a small part of an action will not be sufficient to trigger NEPA. In its Federal Register notice associated with the interim final rule, DOI said that it could make updates to these guidance procedures really at any time. So it's best for DOI and really for all of these agencies to stay up to speed on their guidance documents that appear on their NEPA websites. Moving on to the Department of Energy. Similar to DOI, DOE repealed all of its regulations except those pertaining to administrative and routine actions that will be accepted from NEPA review. Those are now contained in that regulation's Appendix A, which used to be their list of categorical exclusions. The list of existing categorical exclusions are now contained in that regulation's Appendix B. And DOE also retained its emergency response provisions. Then DOE, like DOI, issued separate implementing guidance, separate from the regulations, which contained the vast majority of that agency's NEPA practices. Next up is the Department of Transportation NEPA practices. As you see here, DOT has updated its procedures for considering environmental impacts to incorporate this alphabet soup list of statutes, including the Fiscal Responsibility Act and the Infrastructure Investment and Jobs Act. And then agencies under the DOT have issued their own regulations. They've updated 23 CFR Part 771 due to some specific requirements found in 23 USC 139, which is the Safety LU Act. And you can look up what that acronym means if you want later. Just a few notes here on the FHWA, FRA, and FTA. We note again here that they've modified their regulations. They've removed cross-references to CEQ regulations, so those are no longer there. And then they make updates to their regulations in accordance with NEPA-specific provisions of these statutes that we have listed here. All of the additional NEPA procedures can be found through the DOT guidance portal. And we've given you here the agency-specific websites that you can go to see that guidance. And then the Corps, unlike the other agencies, the Corps rescinded their regulations in full and will be relying fully on the agency's implementing guidance, a link to which is in the slide deck. The other agencies did actually provide a public comment period associated with the interim final rules, primarily having to do with reliance interests and other things not relating to substance. But the Corps chose not to do that. Very briefly, we'll touch on just about a week or so ago, a bipartisan group has introduced a NEPA overhaul bill titled the SPEED Act. The SPEED Act does a number of things. We've listed some of the more interesting things here. Under the SPEED Act, if it were to pass, no NEPA review would be required if an action was reviewed under a state or tribal environmental review statute. It narrows the kinds of actions or what a major federal action would be that would be subject to NEPA review in the first place. It specifies that only the effects that are proximately caused by immediate action under consideration should be analyzed under NEPA, and that NEPA really shouldn't be considering speculative attenuated effects. This probably stems from the language from the Supreme Court in the recent decision in the 7-county infrastructure case, which essentially upheld the Surface Transportation Board's decision not to fully analyze the impacts associated with oil and gas exploration and transportation activities that could occur in connection with the STB's approval of a railway line to the Uintah Basin. Finally, the SPEED Act would require that if you are to file a lawsuit challenging NEPA compliance, the lawsuit must be filed within 150 days of the agency's decision, and that the only remedy would be a remand back to the agency, and that while that remand is ongoing, essentially the agency action that was approved can continue on. There would not be injunctive relief there. I don't have a slide about the litigation, but I did want to mention that, there were a couple of different lawsuits, one over the Trump administration's NEPA regulations, another over the Biden administration's regulations. Those lawsuits have effectively been stayed. The court is reviewing some motions to moot out those lawsuits, and there hasn't been a decision there, but we don't expect to see anything terribly soon from the courts. So now I'm going to turn it over to Brooke to chat about the Endangered Species Act.
Thanks, Rebecca, and hi all. I'm going to briefly go over some of the things that we've seen since we spoke with you earlier this year, kind of what's gone on since the rash of EOs that we saw in January. We're going to focus on Endangered Species Act stuff more generally and then get into some more sector-specific items when we get into the renewable energy section. We saw Secretarial Order 3418, that was the companion to the executive order relating to unleashing American energy. And we saw that they identified essentially a roadmap for where they were going with the Endangered Species Act in terms of which regulations they were focusing on to repeal or modify. In that secretarial order, they noted that they would be revisiting the Section 4 regulations governing listing, delisting, and critical habitat, the Section 4D rule, prohibitions for threatened fish and wildlife, the blanket 4D rule, for those of you that are familiar with it, referred that way, and then the Section 7 interagency consultations, where you have a federal nexus and a consultation process. What we've seen since then, a couple of surprises. We saw the proposed rescission of the harm definition. For those of you that may recall, the take definition, so the prohibition of take is the crux of the Endangered Species Act in ESA Section 9. The definition in the ESA statutory definition section itself, Section 3, includes the term harm. The services later defined harm through regulation. What we saw in April was the services proposed to rescind the definition of harm. They also issued a request for information on Section 10 implementation improvements, so Section 10A1A permits and Section 10A1B permits. And then we've seen multiple proposed rules arrive at OIRA. We'll get into a couple of details on all of these items on the next few slides. So as I mentioned in April, the services proposed to rescind the definition of harm under the ESA. In that proposed rescission, they noted that they had no intention to replace the definition. They also noted that the definition had previously been upheld based on Chevron deference. For those of you that will recall, the big case, the Supreme Court case upholding that definition, was the Sweet Home case from 1995. Part of the basis for upholding that definition was Chevron, and as we all know, last year, Chevron deference was toppled through the Loper-Bright decision by the Supreme Court. The preamble to that proposed rule pointed to the Scalia dissent in that Sweet Home ruling, noting that take and harm require affirmative, purposeful action. So we expect to see a final rule rescinding that definition in whole, probably in the next few months, if rumors are true. At that point, there'll be no definition of harm. There's a suggestion in the preamble along the lines that Scalia said that really it should be more of a purposeful action. How offices will apply it, how habitat modification will be assessed in the context of take, I think will become an open question. And so that's something to keep an eye out for. We noted that there are several ESA regulations that are sitting at OIRA right now. On June 27th, the service sent a number, in some cases the services, and a number of regulatory packages and proposed rules along the lines of that roadmap provided in that secretarial order that I just mentioned. These relate to Section 4 regulations for listing species. It relates to critical habitat specifically, the Section 7 consultation regs, and then threatened species and that blanket 4D rule. So those have all been at OIRA since June 27th. Once they complete their OIRA review, we should see those proposed rules in the Federal Register, but that hasn't happened, at least as of this morning when I checked. We also have some new ESA-related litigation, primarily over that proposed rescission of harm. Again, that's still in a proposed rule state, so that final rescission hasn't hit yet. But in the meantime, the Center for Biological Diversity has sued the service and the National Marine Fisheries Service under FOIA, seeking the administrative record or the documents that supported that decision to propose that rescission of the definition. And of course, we have ongoing litigation over the Biden administration versions of the ESA regulations. Many of those have been stayed. Some of those stays have been helpful in understanding where the services think their timing is. For example, in the hydropower Section 7 case, a recent status update filed indicates that the service is still on track for filing update or proposing updated regulations sometime by October. Again, that's dependent on completing that whole OIRA review, but it shows that that's still, I guess, the intent behind the agencies right now. I'm going to turn it over to Sven, who's going to talk a little bit about some of the non-ESA activity from Department of Interior that's not necessarily sector specific.
Hi, so Ben Brand-Erickson at Nossaman's Seattle office. Just gonna hit a few examples of what Department of Interior has been doing outside of the wildlife space or the ESA space. One of the first actions was taken early in the administration in February of this year was suspension of all Biden era M opinions. M opinions are the formal legal opinions issued by the solicitor's office, and they guide the Department of Interior's interpretation of laws and regulations under their jurisdiction. As part of this action, the incoming solicitor, the incoming administration suspended every one of the M opinions that were issued under the Biden administration and instructed DOI staff not to rely on those M opinions without consulting with the solicitor's office. Picking up one as an example of how this plays out, those who have followed the Migratory Bird Treaty Act issues know that in the first Trump administration, there was an M opinion issued determining that the Migratory Bird Treaty Act does not apply to incidental take of migratory birds. The Biden administration withdrew that opinion and issued a counter opinion. And the Trump opinion was itself a response to an opinion issued at the end of the Biden administration. Of the Obama administration. Now, you can keep all those straight. Now coming into Trump 2, we have rescission of the opinion issued by Biden, and in the course of doing so, also the earlier Obama opinion, and reinstating the opinion from Trump 1 that the Migratory Bird Treaty Act does not apply to incidental take. It's definitely been back and forth between the administrations, but that's an example of how those actions, the M opinion actions, can affect things. Other non-ESA actions, one rule in particular will call out the rescission of the Conservation and Landscape Health Rule. Is sitting at OIRA since April. This rule elevated conservation to a use equivalent with other uses of federal lands for purposes of the Bureau of Land Management decisions. It prioritizes resilience and health of the public lands, and BLM was starting to apply it to make decisions applying the resilience standard at the end of the prior administration. This incoming administration has taken action to rescind it. That rule has been challenged in court. The appeal of that rule is stayed, and in fact, continuation of the stay was just issued today in light of the administration's action to rescind the rule. You want to move on? Also, there is congressional activity that's occurring. Congressman Westerman has been working on an ESA bill. There are a number of concepts. Efforts to reform the Endangered Species Act have been around for decades. This is, a kind of a next step in the process. It's a pretty concerted effort, and there does seem to be, a body of support in the House at least for taking action on the ESA. Identified in the slide here are a number of the issues that would be addressed in this legislation if it were to move forward. We're continuing to follow this quite closely, and I can tell you that the congressman's staff have been very open to discussion of some of the concepts that they are pursuing in this bill. Its future remains uncertain, as does all legislation, but it seems to have more momentum behind it than has been true in a long time. And then I think we move on now to Clean Water Act issues. I'm going to hand it off to Sarah Johnson.
Great. Thank you, Sven, and good to be with you all this afternoon. First up, for Clean Water Act updates, we can kick off with WOTUS and the long-standing debate over which waters require a federal permit. Just a month after our last webinar, the Corps and EPA announced joint guidance on implementation of the term continuous surface connection consistent with the Sackett decision. This March guidance rescinded several of the case-specific memos that had been issued to the field, which memos had stated that adjacent wetlands could meet the continuous surface connection requirement if they were connected to a jurisdictional tributary via a discrete feature such as a non-jurisdictional ditch, a swale, a pipe, or a culvert. The March guidance instead stated that only wetlands that are directly abutting, for example, those that are not separated by uplands, berm, dikes, etc., could be considered jurisdictional, and that continuous surface connections are those where it is difficult to determine where the jurisdictional water and the wetland begins and ends. Interestingly, as some core districts have held regulatory workshops and webinars interpreting this guidance, we've seen some of them indicate that two or more parts of a wetland that may be divided by a discrete feature are still considered the same wetland for purposes of assessing adjacency. So as long as one part of a wetland is abutting a jurisdictional water, regardless of whether other parts of that wetland are divided from the section of the wetland abutting the jurisdictional water, the entire wetland may be considered jurisdictional. Of course, we could see this change with rulemakings that are expected to occur later this year. So continuing on with some updates from March, the Corps also announced then a 30-day comment period and listening sessions that sought stakeholder input on key definitions like continuous surface connection abutting jurisdictional ditches. And as was expected, just about a month ago at the end of June, the agencies did commit to another formal WOTUS rulemaking with a proposed rule forthcoming any day now and a final rule expected by the end of this year. Following this announcement, we've also seen the Corps issue several resources, such as delineation practitioner forms and standards that are intended to increase transparency and consistency in wetland delineations. And lastly, there's litigation, of course. There still are technically two different WOTUS regimes being implemented across the country at this moment due to that state-led litigation. At the moment, proceedings are currently stayed with the agencies filing status reports and citing to the rulemaking as justification for continuing to extend that stay. And why is WOTUS on such a fast track to be finalized by year end? Just to close out there, we know that President Trump has signaled it is a top priority for Administrator Zeldin. It's his #1 priority. He's undertaking at EPA, but there's also interest in attempting to try to codify aspects of the forthcoming WOTUS definition in congressional legislation before those 2026 midterms. Obviously ambitious, but there's interest from a number of different groups in trying to see that WOTUS definition, aspects of it reflected in legislation to provide durability and stop the constant swings in rulemaking. And then moving on to nationwide permits. So the current nationwide permits expire in March of 2026, so we're less than a year out. And an early priority for the Trump administration is simply keeping the nationwide permit program operational with the nationwides reissued before that March 2026 expiration. This tight timeline means that we saw a fairly non-controversial proposal for nationwide permits with what appeared to be a repurposing of sorts of some of the ideas that we've been expecting out of the tail end of the Biden administration. For example, the proposal included several edits that would expand applicability of nationwide permits to nature-based solutions. That comment period closed July 18th, and we're expecting to see fairly quickly the final set of nationwide permits go to OIRA and then be issued as a final proposal. For applicants, it is worth taking a closer look at the district-specific regional conditions that were proposed for the nationwide permits in any of your key core districts where you have projects located to see if there are any regionally imposed pre-construction notifications or other conditions that could be of concern. And this is likely not the last time we will see a nationwide permit proposal under the Trump administration. While the nationwides have to be reauthorized every 5 years, the Corps has the authority to propose other changes before the next 5-year reauthorization. We've heard them indicate an interest in potentially doing so. And so we may see another nationwide permit proposal that really reflects the priorities of the Trump administration, particularly to streamline permitting for the traditional energy sector. So we may see that before the end of the president's term. For the moment, probably the bigger nationwide permit news is for project proponents is just the reality of challenges in obtaining a nationwide permit due to the current uncertainty of having ESA consultations and BIOPs issued following the several DOI actions that have been made targeting ESA implementation for particularly the renewable sector, which I know my colleagues are going to talk about in a moment. And many project proponents are trying to carefully design their projects to avoid potential nationwide permit thresholds and those corresponding PCN triggers, just avoid them altogether. And then closing out on some Clean Water Act updates, we are seeing the House champion a bill. This is similar to what we saw with the Westerman bill. The House is really, particularly in some of their committees, trying to move forward these reform measures that would leapfrog and build off of efforts we're seeing on the executive front. So the Permit Act on the Clean Water Act reflects several of those reform measures that are already underway with the agencies, as well as a few others. A couple of the key provisions we wanted to highlight are codifying that ephemeral features, which they define as features that are flowing only in response to a precipitation event, would not be federally jurisdictional. Directing the Corps to prioritize resources to clear the backlog of jurisdictional determination requests, extending nationwide permits reauthorizations to be every 10 years versus every 5 years, and increasing the qualifying acreage threshold for a nationwide permits for linear infrastructure from that longstanding ½ acre up to 3 acres. So some substantial changes where there's interest in trying to tackle these ideas both on the congressional front and the agency front. That bill, it easily cleared out of House TNI on a fairly partisan line vote at the end of June and is expected to clear the House, but does not yet have a companion bill introduced in the Senate. So those are your Clean Water Act updates, and we'll now move into some sector-specific news, and I will turn it back to my colleague, Brooke. Thanks, Brooke.
Thanks, Sarah. For those of you working in the renewable energy sector, you may be aware that there's been some activity of late. We're first going to start with some of the executive orders that have happened since the last time we were together, and then really focus in on the activity that's been really fast-tracked in the last couple of weeks. I think just this morning, there was another memo issued from Fish and Wildlife Service that we'll touch on. So we'll start big, get into some of the most recent stuff, and then talk about some of the practical implications there before turning it over to Ann-Therese for transportation. There were a few new executive orders and presidential memoranda that have been issued affecting the energy sector since the last time we met. I'm going to go over these three fairly briefly, but we'll go over them for the sake of completeness. We can go ahead and go to the next slide. So the first one we saw was the zero-based regulatory budgeting to unleash American energy. So again, related back to the energy priorities that this administration has focused on. And what it does is it directs agencies to incorporate sunset provisions into certain regulations governing energy production. It's not entirely clear what is a regulation that governs energy or an energy regulation. But if a regulation is characterized as governing energy production, it is subject to the CO, which then calls for the agencies to incorporate a sunset provision. In doing so, the agencies must re-examine the costs and benefits of each regulation. And unless they promulgate a rule providing a different sunset date, there's a conditional sunset date of September 30th of this year. To extend the regulation, there must be good cause to do so. And this edict applies to various agencies, including the Fish and Wildlife Service, BLM, the EPA, Department of Energy, FERC, BOEM, and the Corps. We were talking before we went live, and none of us have seen any activity related to this EO yet, but it's something that is probably going to start happening soon. I think one thing I wanted to note is that the EO states that it does not apply to regulatory permitting regimes authorized by statute. So similar to what is a regulation governing energy, it's not clear what a regulatory permitting regime authorized by statute is, but the EO does apply to energy governing regulations, but does not apply to regulatory permitting regimes authorized by statute. So how that plays out, I think, remains to be seen. We also saw the strengthening the reliability and security of the United States electric grid on April 8th. Requires agencies to use all available power generation sources, particularly secure redundant fuel supplies capable of extended operations. Cites to the Secretary of Energy's emergency authority under the FPA, requires him to streamline emergency processes for forecasted grid interruptions, assess the National Electric System's reserve margins, and publish an analysis of the bulk power system reserve margins, and prevent significant generation sources from leaving the grid if the net reduction of generation capacity would occur. So again, another energy-related EO that came out this spring, consistent with what we've seen the priorities of this administration. And more recently, about a month ago, we saw ending market distorting subsidies for unreliable foreign controlled energy sources. This arises really concurrently with a big, beautiful bill, which seeks to end the renewable tax credits, the PTCs and the ITCs. With the bill's termination of the PTCs and ITCs, the EO directs the Secretary of Treasury and Interior, as those clean energy tax credits end, that they ensure that the term beginning of construction and related policies are not circumvented to extend the duration that those tax credits may apply. And so by August 18th, we should see a directive from the Secretary of Treasury clarifying what beginning of construction means for purposes of qualifying for those tax credits. Just as an aside, the bill says that to enjoy the PTC and ITC, projects must be in service by December 31st, 2027, and there's a safe harbor for projects that begin construction by July 4th, 2026. But again, what it means to begin construction, we'll see more direction from the Secretary of the Treasury. This EO also speaks to the Department of Interior and directs the Department of Interior to review its regulations, policies, guidance, and practices to end preferential treatment for wind and solar energy. And with that, that brings us to the last few weeks of activity that we've seen. And actually, Sven's gonna take a beat and tell us what some of the litigation we've seen over these activities since we last spoke.
All right, so the wind presidential memorandum, for those that don't recall, one of the early actions that the administration took was issuance of a presidential memorandum that both withdrew areas of the offshore from wind development and imposed a moratorium on permitting for all wind onshore and offshore until an environmental review is completed. A suit was filed challenging the permitting moratorium piece of that presidential memorandum. The case is pending in Massachusetts. The US made a motion to dismiss on grounds that there was no final agency action here, that this was just a temporary pause in permitting while they conducted a study, and that basically there wasn't anything to challenge here. The court denied that request. The parties are briefing that the parties will file simultaneous summary judgment briefing on this coming Friday. And the court has set a hearing for September 4th. Rather than consider a preliminary injunction on the permitting moratorium, the court accelerated consideration of the merits. And what that means is maybe in October or so, we'll see a ruling on whether or not the moratorium on permitting for wind projects is lawful or not. There is one other suit I'd mention. Also in May, there was a suit. One of the other executive orders was the presidential declaration of an energy emergency. That was challenged by a number of states, and while there was a lot of attention to it initially, actually nothing has happened in that case other than appearances. There is a case schedule that's being established. There was no injunction effort there, and the briefing on the merits will occur later this fall. The presidential memorandum litigation highlights one of the issues in legal challenges to to the executive actions, basically identifying exactly what is the final agency action that's a necessary element of getting in front of the courts. And I wanted to raise that as we now talk about, let's move on to what Department of Interior has done in implementation of the executive orders. There are a series of actions that have been taken in July and now into August. July 15th, the Secretary's office issued a procedural memo requiring 3-stage review within the secretarial office by the deputy and assistant and the secretary himself on all decisions and actions related to wind and solar facilities. The agencies have interpreted this quite broadly, for example, cutting off access to IPAC for clean energy projects entirely, because that's viewed as a consultation step and requires approval from above. That was then followed up, and that they identified 69 categories of actions, and then including a catch-all for actions related to wind and solar. This was the first action. The prior permitting moratorium was wind, and now we've extended it to solar as well. July 29, secretarial order issued ending preferential treatment for wind and solar projects. This basically is an implementation of the presidential memorandum, or the executive on wind projects, but also the executive orders that Brooke was talking about earlier. In essence, it calls for a couple of immediate actions, but a 30-day review of regulations and permitting processes and a 45-day review of environmental effects of wind and solar projects and of other things. So it basically provides a roadmap for further actions by the administration aimed at changing the rules that apply to wind and solar projects. At the same time, the secretary in a press release said that they would be looking again at the impact of wind on migratory birds and consider enforcement actions. This is on its face inconsistent with the administration's move to determine, as I mentioned earlier, with the M opinions, determine that Migratory Bird Treaty Act does not apply to incidental take. Details are sparse here, but it's something that we're watching very closely. And then 2 further recent actions. August 1, another secretarial order on managing federal energy resources and protecting the environment that basically is designed to make it more difficult to do renewable energy projects on federal land. And then August 4th, and Golden Eagle Protection Act compliance memo was issued, which it was issued as an attachment to a tweet, is so far how we've seen it, that was circulating this morning. So we're still digesting that. Rebecca, next slide, please. The last two items, and I'm gonna let Brooke chime in here on, in this in a minute too. The secretarial order calls into question legality of approving renewable energy on federal lands. Basically, it focuses on the density of land use for energy and suggests that that approval of wind and solar may not meet the basic standard of FLPMA, the Federal Land Policy Management Act, that applies to BLM's decisions, may cause unnecessary and undue degradation, which is the basic management standard of FLPMA, if there are alternatives for producing energy that take less space. This is really a false dichotomy, but it's something they focused on as, in essence, you generate, it takes more space to generate power from renewable energy, but of course, then you aren't drawing hydrocarbons from the ground in the process. The GEPA memo calls for scrutiny of legal permits issued to wind and energy facilities. And next slide, please. And then Interior Secretarial Order 3437 it does, as I said before, it has a 30-day review and a 45-day review, and this slide shows you, what they're going to focus on in that process. I'm going to let Brooke jump in. We want to talk a little bit about the secretarial orders before we move on.
Yeah, so big picture, this is a lot of action in the last few weeks, right? With the DOI memo or the DOI Secretarial Order 3437, we see that, well, let me go back. There's the DOI memo that lists 69 different types of documents that are now going to be subject to this 3-tier review process for wind and solar. Some of those items are arguably not statutorily required, absent some sort of permit condition requiring their submittal to the agencies, right? So, how and when those documents are going to make it to the agencies to invoke this review process, I think there's some questions there that we can discuss either during the roundtable or through Q&A. I think there's also what's going to happen with that review process. Will that review process actually happen? Will approvals and things pop out? Or are things just going to sit indefinitely? I think that remains to be seen. I think field offices and how they're going to proceed under this review process that's called upon by that DOI memo, I don't think the field offices know yet. I think some have indicated a concern, even having conversations with the project proponent, because they're concerned that any of their communications need to go through the review process before it goes further. To Sarah talking about the nationwide permits, if you have a nationwide permit and you have a general condition 18 trigger under Endangered Species Act Section 7, that's invoked by listed species, proposed species, plant species, critical habitat, proposed critical habitat. If you have a PCN trigger, a pre-construction notification trigger to the Corps, and the Corps feels obliged to discuss with the service, depending on what their finding and conclusions are, that process is arguably captured by that DOI memo. So a fairly rote PCN that would typically go for the standard verification processes for those PCNs that implicate conversations with the service, arguably that's invoked by the DOI memo and subject to that review process. We've known for a while with the Corps, we talked about this during the last webinar, that the Corps is not issuing verifications for wind nationwide permits pursuant to the WIND-EO. And that actually extended beyond just nationwide permit 51 for renewables, but also to ancillary structures permitted under nationwide permit 57, utility lines, collector lines, nationwide permit 14, access roads. A few had a PCN trigger seeking verification, and it was ancillary infrastructure supporting a wind energy facility. The Corps has not been willing to process those verifications. Now, through the DOI memo, where you have a solar PCN that may invoke a discussion with any of the DOI agencies, so really Fish and Wildlife Service under General Condition 18, you now have that DOI memo kind of seeping into that permit program as well. I had a couple notes here that I wanted to touch on before we change over to the other sector. Let me just take a look. I mean, I think a lot of unknowns, a lot of figuring out how these processes play out. I think what we see from this particular secretarial order that's on your screen, 3437, it's, as Sven already said, it's a roadmap for where they're headed in terms of review. Between the Eagle memo that was issued this morning or through the tweet yesterday, through the press release that touched on Migratory Bird Treaty Act, through the secretarial order that lists Migratory Bird Treaty Act, Endangered Species Act permits, Eagle permits. You see an intent of the Department of Interior in particular to revisit some of these processes and how they're being applied to renewable energy under that Unleashing American Energy Directive. So where they're going to go with those processes, how it's going to affect how they're looking at enforcement and incidental take, I think remains to be seen. But I think they flagged that there will be some changes there and that we'll see that in, the coming months. I think from there, we can go ahead and touch on the FAA and Department of Transportation slide briefly. Oh, actually, we had federal lands next.
Yeah, just
Back to you, Sven, sorry.
yeah, just real quickly, the rescission of right-of-way leasing and operation of renewable energy. This is a BLM rule on rights-of-way leasing and, particularly setting lease rates and terms for leasing to federal lands to solar and energy. It is in the process of being rescinded by this administration. And they intend to rescind the renewables right-of-way rule, which also is a related rule that provided rate reductions and was viewed by this administration as biased in favor of renewable energy. I would note these are, real rulemaking actions. I want to just one thought from what Brooke said. I just want to hit before she goes to FAA is this is very much a roadmap. They are telling us where they are headed. Very few of these things are actually final actions, except for the unwillingness of agency personnel to consult and provide information. And that is, as much as anything, their lack of understanding as to what they're being asked to do and how they're supposed to be implementing the directives from above. But what we really have to watch for is how some of these things are translated into actual changes in policy or regulation, because the rules on the are still in the books that allow right-of-ways for wind and solar today. Go ahead. Next slide, please.
All right, back to me now. I'm back in order. To briefly touch on just a couple questions that I'm seeing in the chat, and thanks, you guys are putting up some great questions. Will any of the reviews and reports be made public? If you guys will recall, a lot of those January 20th EOs and subsequent secretarial orders similarly directed the agencies to produce reports, and by and large, those have not been made public. I think we can see the results of them based on what's popping out at the Federal Register and that sort of thing, but there's no guarantee that they'll be made public. With respect to the wind EO, wind assessment, that's supposed to be kind of the thing that the wind EO directs to be done before wind permitting can start again. I don't have a great update. There's different rumors that come around of folks working on it. I think some of the assessments that you're seeing called for in some of these secretarial orders feel like they should feed into something like that. But Sven, I don't know if you've heard anything different. I haven't heard anything tangible about whether that assessment is being done in earnest or what sort of timing or results are expected to come from it.
Yeah, I have not heard anything, and I actually think I'm interpreting the secretarial order and the studies called for under the secretarial order as a kind of an elaboration on that call and maybe basically the same thing.
All right, same. Briefly, I just wanted to talk on another announcement that came last week from different agencies. On July 29th, the Department of Transportation Secretary Duffy announced that the Department of Transportation will implement recommendations for a 1.2 mile setback for turbines near highways and railroads due to concerns related to radio frequency. They'll also be conducting a study to collect additional data to inform safety guidelines for wind turbines. And then the announcement concluded with a mention that FAA will thoroughly evaluate proposed turbines for aviation safety. How this plays out, I think, is a little bit unknown. We haven't seen FAA put out new regulations or indicate that they're going to be revamping anything about that determination of no hazard process. With DOT, the recommendations for the 1.2 mile setbacks arose under the IRAC process with the NTIA. And so for folks that voluntarily submitted to NTIA to go through an analysis of radio frequency, that recommendation was showing up during some Biden era reviews. And so what DOT has said is, well, that recommendation was ignored, and going forward, we are going to make that recommendation. But that really, the opportunity for that to arise is really through that NTIA IRAC process. And where that can actually go to be binding, I think, remains to be seen. So just wanted to touch on that. And then also ending on Department of Transportation seems like a great way to turn it over to Ann Therese.
Nice segue, Brooke. Thank you. My name is Ann Therese Schmid. I'm a partner in Nossaman's Washington, D.C. office, and I practice with our infrastructure practice group. Today, I'm going to provide a high-level overview of federal funding and policy issues related to highway and transit projects specifically, although many of the policies being discussed are also relevant to other operating administrations within the US DOT and generally to other recipients of federal grants and loans. With the caveat to be sure that some of the operating administrations are moving faster than others, and some OAs have different opinions than others, but generally these topics are relevant across US DOT. And to take time real quickly for a shameless plug, my colleague Shant Boyajian and I will be providing a webinar next month that will delve more deeply into the transportation specific federal funding and policy issues that I'm going to touch on here today. So moving on to the topic of federal funding updates, we'll discuss first the National Electric Vehicle Infrastructure Program, and then we'll touch on the Neighborhood Access and Equity Program before moving on to a discussion of policy developments. So if you recall from our prior webinar, we talked briefly about some of the funding issues that went on around specifically the NEVI program, but generally transportation funding. And they arose mainly out of Executive Order 14154, which was Unleashing American Energy, which was issued at the outset of the administration, and a series of Office of Management and Budget memoranda that came out around that EO relating to pausing the disbursement of federal funds, and a broad pause, and then scaling that back, a rescission of the broad pause and scaling it back to effectively federal funds that relate to what the administration was referring to as the Green New Deal funding. After that, the Federal Highway Administration on February 6th issued a memorandum that suspended approval of state electric vehicle infrastructure deployment plans, and also rescinded the NEVI formula program guidance. And this effectively had the effect of effectively suspended all of the funds for the NEVI program that had been appropriated and authorized for that program. So since that February 6th letter, there's been a few actions that have happened. The Government Accountability Office determined in a May 22, 2025 decision that the withholding of the NEVI appropriations by US DOT was unauthorized under the Impoundment Control Act. I will note that OMB then issued its own letter advising US DOT to disregard that GAO determination. That letter was issued on June 3. And OMB's basis was that they felt that GAO did not fully understand the legality around the US DOT's decision to repeal and rescind its guidance and subsequently withhold the funds. After that, GAO also issued a report in July of 2025 that indicated that FHWA lacked a fully defined performance goal for both the NEVI program as well as for the Charging and Fueling Infrastructure Discretionary Grant Program. So the NEVI program right now is awaiting some further action, including new guidance to be issued by the FHWA We don't have a timeline for that new guidance, but we do know that draft guidance has been submitted to the Office of Information and Regulatory Affairs. That was submitted on July 1. So we're waiting to see what action comes out of that. In related news, the state of Washington and some other states, 14 other states, filed a lawsuit against USDOT in the Western District of Washington. And that lawsuit requested an injunction on USDOT from withholding the NEVI funds for the 14 states. A preliminary injunction was issued on June 24th. Which suspends or revokes, that enjoins USDOT from suspending or revoking any previously approved state electric vehicle infrastructure deployment program or plans, and enjoins USDOT from withholding or withdrawing any NEVI formula program funds where there has been a previously approved plan in a state. The injunction was granted for 11 of the 14 states. It's not a nationwide injunction, it's specific to those 11 states only. And then just really quickly touching on the Neighborhood Access and Equity Program. This is a discretionary grant program that was created in the Inflation Reduction Act. Subsequently, Congress rescinded any unobligated balances of amounts made available under this program in the One Big Beautiful Bill Act, which is the budget reconciliation package that recently passed. So what that really means, there was $3.2 billion awarded under this program, $2.4 billion of which was unobligated, and those are the funds that have been rescinded under the OBBBA. This will affect approximately 78 projects, which will lose the funding under that rescission. Just one point of note and clarification, this program is closely related to the Reconnecting Communities pilot program, which was established under the Infrastructure Investment and Jobs Act. That program is in fact still funded at this time. So practically speaking, what does all of this mean related to funding programs? It's inevitable that there will continue to be changes to the federal funding programs, particularly with the fiscal year 2026 appropriations process underway, and the fact that discussions and listening sessions related to reauthorization of surface transportation programs is underway, with the current reauthorization expiring in 2026. So we are encouraging everyone to be sure that when discretionary notices of funding opportunity are coming out, look closely for changes to requirements, both policy changes and evaluation criteria. And make sure that you do understand that grants that are awarded but not obligated could still be amended or canceled by USDOT, as we saw recently with the Neighborhood Access and Equity grants. And also note that grants that are obligated could still be amended or terminated. Amendments to grant obligations under many of the grant agreements can be self-executing. And there are regulations in 2 CFR Part 200 that relate to amending grants, as well as terminating grants when a recipient fails to comply with the terms and conditions of the award. So now we'll move on to a discussion of policy developments in the context of executive orders, and then we'll talk about some administration policy directives, regulatory updates, changes to federal recipient requirements, and some outstanding litigation. We'll focus on these 5 executive orders and the policy guidance and regulatory changes and litigation that have arisen from them. So we're looking at 14151, which is ending radical and wasteful government DEI programs and preferencing. 14159, protecting the American people against invasion. 14168, defending women from gender ideology extremism and restoring biological truth to the federal government. 14173, ending illegal discrimination and restoring merit-based opportunity. And 14224, which is designating English as the official language of the United States. So as we talked about in our last webinar, at the outset of the administration, USDOT issued 2 policy documents on January 29. The first was a memorandum directing the Office of the Secretary of Transportation and the OAs to rescind certain US DOT orders, directives, rules, and guidance. And the other document was an order directing rigorous economic analysis and positive cost benefit calculations and requiring agencies to avoid adverse impacts on and maximum benefits for families and communities when looking at and reviewing projects. So since then, we've had a few updates, mainly in the DEI arena, but also related to immigration enforcement. So first, on February 5th, United States Attorney General Bondi issued a memorandum entitled Ending Illegal DEI and DEIA Discrimination and Preferences. And this memorandum indicates that the Department of Justice's Civil Rights Division will investigate, eliminate, and penalize illegal DEI preferences, mandates, policies, programs, and activities in the private sector. It does not prohibit educational, cultural, or historical observances that celebrate diversity, recognize historical contributions, and promote awareness without engaging in exclusion or discrimination. Subsequent to that, on April 24th, US DOT Secretary issued what's kind of colloquially called the Follow the Law Directive Letter. This was issued to all US DOT grant recipients, stating that policies or practices designed to achieve DEI goals presumptively violate federal law, and federal funding recipients are precluded from allocating federal funds based on suspect classifications. The letter also reinforces cooperation and not impeding United States Immigration and Customs Enforcement and Department of Homeland Security enforcement of federal immigration law, and indicates that a failure to cooperate with ICE and DHS may give rise to civil and criminal liability, enforcement actions, comprehensive audits, recovery of funds, and/or termination of federal funding. After that, on May 19th, Deputy United States Attorney General Blanche issued a memorandum generally addressing False Claims Act. But what it really does is build on Attorney General Bondi's February 5 memo. And under this memo, DOJ indicates that one of the best ways to accomplish the outcomes set forth in AG Bondi's February 5 memo is through vigorous enforcement of the False Claims Act. And it also encourages private parties to file lawsuits and litigate claims under the FCA related to illegal DEI programs. On July 2, we then had a policy update from Secretary Duffy via a July 2 letter that indicates that US DOT will no longer enforce and considers to be null and void and of no effect any orders, directives, rules, regulations, notices, guidance, documents, funding agreements, programs, and policy statements that relate in any way to climate change, greenhouse gas emissions, racial equity, gender identity, DEI goals, environmental justice, or the Justice 40 initiative. So this really harkens back to the US DOT January 29th order that came out at the outset of the administration. And then finally, just last week on July 29th, US Attorney General Bondi issued a new memorandum that provides practical recommendations to minimize the risk of violation of federal anti-discrimination laws. So again, this builds on the February 5 and May 19 memoranda that came from Department of Justice related to DEI programs. In this new memorandum, it indicates that using race, sex, or other protected characteristics for employment, program participation, resource allocation, or other similar activities, opportunities, or benefits is unlawful, except where such discrimination satisfies relevant judicial scrutiny. And they use as an example having gender separate bathrooms. It also warns against what they're calling unlawful proxy discrimination, which they describe as facially neutral criteria that function as proxies for protected characteristics if those proxies are designed or applied with the intention of advantaging or disadvantaging individuals based on protected characteristics. Finally, this particular memorandum extends scrutiny to third-party programs supported by federal funds. So now we'll turn to the regulatory updates that are being noticed pursuant to USDOT's January 29 memorandum that asked OST and the OAs to take a look at their regulations. So first we have rescissions and amendments to Federal Highway Administration regulations that were noticed in the Federal Register on May 30th. There's 16 regulations identified here. I'm not going to go into the list, and if you have questions or want to look at these more in depth, I encourage you to go to the May 30th Federal Register edition and review these NPRMs. But there was a number here, and then moving to FTA on the next slide, thank you. Similarly, regulatory updates were noticed on July 1 for Federal Transit Administration regulations, a total of 12. And again, I won't go into any of these in depth today, but it would encourage anyone looking for more information to go to the July 1 edition of Federal Register. Or of course, feel free to reach out to us with any questions. In addition to the US DOT regulatory update, Department of Labor, through its Office of Federal Contract Compliance Programs, also issued rescission and modification to its affirmative action regulations, which are found at 41 CFR Part 60. This applies really across the board to the majority of federal agencies. So this is a pretty big change. Comments are still open on this. The comment period, they're due September 2nd. So we encourage folks to take a look at that as well. And so moving to some of the updates to the USDOT Operating Administration's various federal requirements for recipients. All of these updates flow from the EOs and the policy directives and now these regulatory changes that I just referenced. So we'll talk first about Form FHWA 1273. This is the FHWA's form that is actually set forth in the Code of Federal Regulations, and that lays out all of the requirements for federal recipients, their contractors and subcontractors. So in the May 30th notice of proposed rulemakings that FHWA issued, FHWA is proposing to remove 23 CFR Part 63 Subpart A, which is for Form FHWA 1273. Currently, the regulation requires recipients of FHWA financial assistance and their contractors and subcontractors to actually physically incorporate this form into any contracts. With the changes that USDOT is proposing, recipients, contractors, and subcontractors may incorporate Form FHWA 1273 voluntarily, but would no longer be required to do so. I would note that FHWA is not updated Form FHWA 1273, so if a recipient, contractor, or subcontractor chooses to continue using it, you will want to make changes so that the form comes into compliance with the EO's policy directives and regulatory changes that I just cited. The comment period on this particular change has closed as of June 30th, so the FHWA is taking no additional comments on this. And then discussing Federal Transit Administration, of course, their requirements for their federal recipients flow through their master agreements. FTA issued 2 updates to its master agreements. The first was on March 26th. And that update generally did a handful of things. It struck any references to gender identity, to Executive Order 11246, references to environmental justice, and any references to USDOT's and OFCCP's affirmative action regulations. So any references to 49 CFR Part 21 and 41 CFR Chapter 60. It also revised a provision related to access to services for persons with limited English proficiency and struck references to EO 13166, as well as USDOT's notice entitled DOT Policy Guidance Concerning Recipients' Responsibilities to LEP Persons. Lastly, this update on March 26th adds provisions related to EO 14173 including a certification that a recipient is not operating any programs promoting DEI in violation of federal law. Then the April 25th changes came out to the Federal Transit Administration's master agreement, and that included two changes. It struck provision requiring recipients to have an FTA approved disadvantaged business enterprise program, but did retain other DBE related requirements. And it also added a provision requiring recipients to cooperate with federal officials in the enforcement of federal law, including cooperating with and not impeding ICE and other components and offices of DHS in the enforcement of immigration law. So finally, we'll turn to litigation related to US DOT programs and policies. First, the litigation update for King County versus Turner, which was filed in the Western District of Washington. Under this litigation, local governmental entities are challenging the new United States Department of Housing and Urban Development and US DOT grant conditions, including the DEI changes as well as the immigration changes that we just discussed. Under this particular filing, a preliminary injunction was issued on June 3 and applies only to named plaintiffs. So in other words, this is not a nationwide injunction. But under the injunction, US DOT and HUD are enjoined from imposing or enforcing new language, rescinding, withholding, canceling, pausing, freezing, blocking, terminating, delaying, or conditioning any grants, and nullifying new grant conditions in already signed grant agreements. Another case that was recently filed is State of California versus US DOT, which was filed in the District of Rhode Island. Under this particular litigation, several states challenge Secretary Duffy's April 24 follow the law letter, specifically the immigration enforcement conditions and any subsequent grant conditions that were then placed based on that. Again, a preliminary injunction was issued on June 19, which applies only to the named plaintiffs, not a nationwide injunction. And under this injunction, US DOT is enjoined from enforcing immigration enforcement conditions and withholding or terminating federal funding based on the immigration enforcement conditions. I'm going to take these next two out of order. I'm going to talk first about City of Seattle versus Donald Trump. This was just filed July 31. And this lawsuit challenges Executive Orders 14173 and 14168, claiming the language in the EOs is overly broad and not reasonably related to any federal interest in the plaintiff's projects. Specifically, it cites concerns that the vagueness of what constitutes a quote-unquote illegal DEI program under EO 14173 creates False Claims Act exposure. So again, looking back to the memoranda that DOJ issued on February 5 and May 19th, and the filing similarly cites concerns that EO 14168 requires agencies to ensure grant funds do not promote gender ideology without actually indicating what promotion of gender ideology is. So we're waiting to see how this case develops as it's freshly filed. And then lastly, I'm going to talk about Mid-America Milling Company versus US DOT, which was filed in the Eastern District of Kentucky. This is a little bit of a different case because, just to note, Mid-America Milling is a lawsuit that was filed under the prior administration challenging US DOT's Disadvantaged Business Enterprise Program. It's been winding its way through the Eastern District of Kentucky. It went up to the appellate level and is now back in the district. But there have been some updates under the new administration, specifically that the parties together filed a motion for entry of a consent order on May 28th. And that consent order would stipulate that use of race and sex-based rebuttable presumptions in the determination of DBE eligibility is not supported by the Constitution as it is currently interpreted. And it also stipulates that race and sex-based rebuttable presumption of social and economic disadvantage used in USDOT's DVE program violates equal protection under the Fifth Amendment's Due Process Clause. It asks the court to hold that the use of DVE contract rules based on the race and sex-based rebuttable presumptions violate equal protection. So right now, interveners are submitting filings both in opposition and support of the consent order, and we're waiting to see how the court proceeds. So just some quick practical guidance related to these policy changes. Of course, the policy landscape is going to continue to evolve, particularly with, various rescissions and modifications to regulations open right now in the Federal Register, as well as any outstanding litigation related to some of these policies. So just watch as the OST and OAs complete reviews of their respective programs and policies. Grant recipients should be aware and on the lookout for direction from their applicable OA in the form of notices of proposed rulemakings, revisions or amendments to current NOFOs, and rescissions or revisions of current or implementation of new guidance and policy documents. And also understand that OAs may opt to unilaterally amend executed grant agreements to comply with the administration's policies. I'm just going to jump really quickly into water infrastructure. So effectively, the EOs and the DOJ memoranda, as well as the Department of Labor's proposed rescission and modification of its affirmative action regulations, all apply to water infrastructure projects as well. So just really quickly touching on Water Infrastructure Finance and Innovation Act. We had an update in May of 2025 to WIFIA's specification package in bid contract language. This particular update adds references to EO 14173. It removes any requirements for a DBE program under the WIFIA loan program. And it also retains references right now to the affirmative action program and USDOL's regulations at 41 CFR Part 60, but explicitly notates that once DOL revokes those regulations, compliance will then not be necessary. In addition, the Environmental Protection Agency has issued updates to its general terms and conditions. Those were issued April 3. And they include an updated termination clause related to compliance with policy, administration policies. It adds federal anti-discrimination clause that aligns with EO 14173. And it updates other civil rights obligations as well as utilization of DBE clauses, and updates the RCRA clause as well as the clause pertaining to establishment and management of subawards. So that was a lot, but with that, I'm going to turn it back to Rebecca for our roundtable discussion.
Thanks, Anne-Therese. I want to go back to water for a minute. I see that there are several water agencies on today who are trying to navigate all of these things in the state of California. Sarah, do you have any thoughts on how the state has been responding to all of these federal developments?
Yeah, thanks, Rebecca. For those operating in California, it's a challenging environment. Not only are we trying to keep up with the federal changes, but also California's expected swift actions in response to those changes. On the funding front, several state revolving loan funds that are dependent on supplemental federal funding are at risk, and the State Water Resources Control Board is bracing for those potential changes with program adjustments. We're also seeing that the state legislature is taking steps to try to increase funding for state water permit staffing, and the legislature is reacting directly to some of these Clean Water Act and ESA reform measures that are playing out. Two bills of particular interest this legislative session have been Senate Bill 601 that's on wastewater discharges. It would create this new category of nexus waters under state protection that are filling the gap following the loss of federal protections after the Sackett decision. And it would also authorize the state to pass new wastewater discharge requirements for discharges of effluent, stormwater fill. And then also we're seeing the state react to the ESA changes with Assembly Bill 1319, Protected Species under CISA. This bill would emergency list 18 federally listed species that were formerly federally listed to now list them under CISA. And the bill has raised a number of questions for folks on what that means for existing permits, what this means for the best permitting mechanism for those emergency listings moving forward. So a lot to watch here and track in California, particularly through the end of this legislative session, and would recommend, being involved in your industry organizations to stay plugged in and have influence. Both of those bills that I mentioned are headed for appropriations actions and through the committees once the legislature is back in August. Thanks, Rebecca.
Thanks, Sarah. Brooke and Sven, a couple of questions came through during the presentation that I think we could address pretty quickly. And then I have another couple of questions relating to renewable energy. But the first question was whether the FAA can serve as a federal nexus for wind turbines, triggering the need for DOI review.
Yeah, so I believe there's case law here, and Sven, correct me if I'm wrong, but FAA takes a very narrow view of its federal action in issuing those determinations of no hazard such that they don't conduct a NEPA analysis or ESA Section 7 analysis. So the implications of that DOI memo creeping into the FAA process, I think, as it currently stands and is applied, would not implicate the DOI memo. Is there a chance that they come out and revise the regulations in a way that changes that practice at this point, given what we've seen in the last few weeks? Sure, but as it stands in historical practice has been that it's been a very narrow view that does not trigger additional NEPA or ESA Section 7.
Thank you. We also got a question about potential timing on a tricolored bat listing. Do you have anything to share?
We have not seen an updated unified agenda or U.S. Fish and Wildlife listing work plan. As you all know, that listing is well overdue in the interest of deregulation and the number of industries that particular species would impact. I'm not sure it's particularly likely, though me saying that out loud may have just jinxed it into existence. But it remains a proposed endangered species. We haven't heard a better update. We also haven't seen a lawsuit filed by NGOs for the missed deadline. So that's something we're keeping our eyes peeled for.
Okay, thanks. Another question I have, Brooke and Sven, is whether operating projects are excluded from activities that are aimed at curbing renewable energy at the moment.
I would say they have been so far. However, some of the actions that were announced by Interior in the last week, 2 weeks, do implicate existing projects, particularly Migratory Bird Treaty Act and Bald and Golden Eagle Protection Act actions do raise the prospect of the agency taking actions that could affect existing projects. We're also going to be watching to see as they revisit rulemaking on how, for projects that are on federal lands, is BLM going to try to change the rules that apply to those projects on things like what kind of bonding is required and such. But, overall, I think so far the focus has been on new development, but we're watching for the potential impacts on existing projects.
I'll add the wrinkle that I agree with Sven, except for as it relates to risk management strategies. So Sven mentioned the eagle and migratory bird risks that operational wind projects may pose. I think also on the BAT ESA operating wind, it's a common practice within the wind energy industry to seek technical assistance letters that prescribe a curtailment regime that the service believes is unlikely to result in take, and in return, the project proponent conducts monitoring and whatnot and submits reports. That's all an entirely voluntary process. Service guidance is pretty clear that it's the project proponent's responsibility and prerogative to determine their risk of take and then proceed to get a permit or not accordingly. But those comfort letters, that's essentially what a technical assistance letter is. It's a comfort letter. It doesn't have a regulatory place, have become the norm, particularly expected by financing parties and whatnot. And so I think now there's a question about making those risk assessments in coordination with the agencies and seeking that TAO. Arguably all of that is implicated by that DOI memo. And so project proponents that have operational risk may start changing that common practice and reverting back to something more akin to the kind of general service guidance that it's the project proponent's prerogative to determine their risk and not seek those comfort letters, because that might, and arguably does as written, trigger the entire review process.
Brooke, your last kind of set of thoughts bring another question to mind, which is what sorts of things are we recommending to project proponents to try and ameliorate some of the activity that DOI is taking?
Yeah, I think one of the first things that folks are doing are evaluating their portfolio to see which projects are going to have a federal nexus that's unavoidable, where there's opportunities for project redesign or engineering redesign that allow for them to proceed on non-federal lands with no federal nexus and go about managing that risk without having to go through an approval. And then I think it's already what we've alluded to, or what I've alluded to a couple of times, is there's a lot of things that the renewable energy industry does, particularly the wind industry, that's become common practice, but that's actually all voluntary. So a lot of voluntary submittals and meetings with the agencies that are not required by statute. And I think the way that that DOI memo was written, all of that is arguably implicated in that review process. And so I think rethinking what you're submitting is part of the calculus, but there's also managing financing party expectations and educating them on why that practice may not make sense now. And thinking about where that risk tolerance and risk comfort is based on the circumstances of a project.
Yeah, and that leads perfectly into the next question, which is whether anybody has thoughts about financing generally.
Go for it, Brooke.
I mean, I think it's not a fun place right now for financing parties or project proponents in managing all the uncertainty, particularly as we start to see more discussion of enforcement risk and those sorts of things. I think there's going to be continuous conversations, educating and recalibrating common practices to manage risk going forward as everything changes by the day.
Thank you. And Therese, I don't want to leave you out. I want to ask a couple of questions on transportation. One, do you anticipate public-private partnerships will continue to be encouraged in the transportation space under this administration?
Yeah, the short answer to that is yes, although we do have to see what continued changes we have to policies moving forward. But generally, the current administration has indicated a willingness and a friendliness toward private participation through public-private partnerships. For example, on July 7th, Secretary Duffy announced that the percentage of eligible project costs that could be financed under the Transportation Infrastructure Finance and Innovation Act would increase from 33 to 49%. So that's opening up an opportunity to a lot of projects to incorporate a TIFIA loan, which would encourage public-private partnerships and private participation. So, similarly, some of the early directives that came out of OST related to the transportation program specifically identified projects with user fees, and that again is another opportunity for bringing in private parties to participate through P3s or other forms of contractual arrangements in your project. So we're hopeful and looking forward to potentially having a wider berth for P3s to be developed particularly in the transportation industry.
Thanks, Anne-Therese. We're just now a little bit over time. We'll continue to talk for just a minute or two. You're welcome to stay on or drop off, and we really appreciate you joining us today. Anne-Therese, do you have any thoughts about NEVI funding and fiscal year 2026 appropriations process?
So we're hot and heavy in the THUD fiscal year 2026 appropriations. Right now, the Senate version of their THUD bill does direct FHWA to issue the guidance that we've been waiting for within 30 days after any appropriations legislation is enacted. You know, as I noted, that guidance is in draft form right now at the Office of Information and Regulatory Affairs, so it could come out prior to this becoming an issue through the appropriations process. But if not, that could serve as a spur to restart the program. But on the flip side, I will note that the House version of the THUD appropriations bill currently redirects $1 billion from the NEVI program over to the Federal Aviation Administration for facilities and equipment. So between the two chambers, we're going to have to get some agreement on NEVI and how it moves forward, if it moves forward. But ultimately, we are really going to be looking to reauthorization in 2026 and whether the program is continued or not continued. And if so, what the funding limits would be.
Thank you. Maybe just a couple more questions. We had several people ask about the use of IPAC for renewable energy projects now that, you know, we have the banner that says, you know, you can't use it. So Brooke and Sven, thoughts on, you know, how best to manage species lists and consultation obligations in this world?
You want to go, Sven, or you want me to?
Oh,
Either
you go.
So for folks that are unfamiliar, IPAC is a tool that the service provides where you can either go by county or draw a polygon around your project area to determine what species may be implicated by your project footprint. And it really is, its purpose is to serve ESA Section 7 consultations, right? To give you a preliminary inventory of what species may need to be evaluated for that Section 7 purpose. Right now, they're saying it's not available for wind and solar. We know that the service has a review process for things like Section 7 consultations involving wind and solar. It's implicated by the DOI memo. It's going to go up through that review process. To me, and I don't mean to be cavalier here, I think them shutting down the IPAC process for wind and solar is a bit silly to me. You could still draw a polygon and not identify what type of project and determine what sort of species you have. If you have a federal nexus and you know you may be headed towards a Section 7 consultation, that conversation is going to have to happen at some point anyway to get that process really going. If you're using it for your own diligence and evaluation, I think either you're using IPAC and not necessarily identifying the type of project, or you're working in conjunction with your biological consultants for them to do an inventory of what they know because of their familiarity with the project area, with the county, with the species that may be present, and just going about it a different way. And so I think for purposes of non-Section 7, Section 9 diligence type issues, your biological consultants, or using it just as an informal way to think about what species you need to be aware of is fine. I think if you actually have a Section 7 trigger, at that point, at some point, when the service will start talking Section 7 consultations with you, that information is going to just have to be part of the exchange.
Thank you.
I would just throw in, as a general matter, you know, there's a question about whether companies should continue to do pre and post construction surveys and other things. In a situation where the service is unwilling to consult or talk, does it make sense to continue to do the things, collect the data that you would otherwise collect, and just even if you hold it internally? I think the answer is yes. you need to think of this as, those are steps that you're taking to demonstrate good faith and trying to comply with requirements. And you follow those steps and document you've taken them, and they'll put you in a position to either deal with the agency when its approach changes or demonstrate that you have taken the steps that are required, if it ever becomes a compliance issue.
Thanks, Finn. So I think we're about out of time. If we did not get to your question and you have other questions, please feel free to reach out to any of us on this panel, and we'd be happy to chat. We appreciate your time today and hope to see you at another webinar soon.